I'm here with Jed Stone. Jed Stone is a nationally recognized criminal defense attorney. He has been an adjunct professor at Northwestern University Law School. He has litigated many death penalty cases, came out as a fervent advocate against the death penalty, or a fervent opponent of the death penalty. He's received the NAACP Freedom and Justice Award. He's been mentioned in the who's who of American law. He is a preeminent criminal defense attorney, and in interviewing him today, it's my hope that he can shed some light on what it is that makes him so good. So it's good to have you with us, Mr. Stone.
It's an honor and privilege to be here. I can tell you in a short paragraph what, quote, makes me so good, close quote. And the answer to that is my mom. My mom instilled in me a desire to fight for the underdog, a desire to express contrary opinions in a thoughtful and persuasive way. When I was 6 years old, we were leaving synagogue on a Friday night. And as we were walking back to the car, my mother said, "What did you think of the rabbi's sermon?" 6 years old. And I said, whatever I said, who knows? And she said, "That's really interesting. Let's tell that to the rabbi." And she turned me around and walked me back to the rabbi, who was, 6 feet tall to my 6-year-old self. And I looked up at him and I said whatever I said, scared to death about, God's emissary on earth, and I'm going to critique him. But that's the household that I grew up in. And I remember when I'm standing in a courtroom, especially appellate or Supreme Court rooms, and the justices are coming at me, I remember my mother holding my hand and saying, "Let's tell that to the rabbi," figuring that someday, sometime in the future, I would be standing in front of judges and have to talk to them without fear. I came home from college one night, and we were all sitting at the dining room table, kitchen table, and my father asked me a question. And I answered the question, "Because." And my mother interrupted and said, "Because, Jed? Do we fight for a cause?" And I said, "No, because, Father, we fight for a cause, Mother." And that's the household I goddamn grew up in. So you want to know how you become when I was 8 years old, third grade, for my birthday, my mother bought me the Clarence Darrow biography by Irving Stone. I didn't have a choice. This was in my
No
DNA.
relation, I'm presuming.
No, Irving was not a relative. But before we started on tape, I said I wanted to tell a story, and I do. I think this story capsulizes my view of being a criminal defense lawyer. Many years ago, I represented a fellow by the name of Maurice Jones. Maurice was charged with murder. His neighbor had been found with her hands tied behind her back with a coat hanger. She had been strangled to death. Next to her body, there were 2 cocktail glasses. One cocktail glass with her fingerprints on it, and one cocktail glass with Maurice's. Maurice was on parole for murder. That is, he had gone to prison for a murder that he had committed earlier, served his time, and was now out. So we had a murderer, paroled, now charged with a new murder, and very serious evidence at the crime scene. I knew that this was a death penalty case because in the dark ages when Illinois had a death penalty, this was a second murder, which would make it eligible if the jury found him guilty. I also knew that if the jury found out that he was on parole for murder, they would stop listening to any of our defenses. We had a very good judge. I filed a motion to keep out the previous murder in the guilt innocence phase. Of course, it could be used in the penalty phase if, God forbid, we got there. The judge granted that motion. We went to trial. The trial lasted a week and a half, a little more than a week and a half. And on a Thursday morning at about 11 o'clock, the jury went out to deliberate. They were out all day Thursday. into the evening on Thursday, went home that night. Friday came in at 9 o'clock, worked all day and all evening. At 11 o'clock at night, the judge called us into the courtroom, called the jury in and said, you want to go home, or do you think deliberating a little longer would arrive at a verdict? The foreman told the judge at 11 o'clock on a Friday night, give us a couple of more hours. I went back to the jail with Maurice, and I realized that if they found him guilty Saturday morning, on Monday, we would be back in that courtroom fighting for his life. And then they would find out about the other murder. And then they would stop listening to me. And then we would be in deep, 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 deep trouble. 2 o'clock in the morning, a sheriff came into the jail where I was visiting with Maurice and said, we have a verdict. We went back to the courtroom. The judge called the jurors in. Mr. Foreman, have you arrived at a verdict? We have, Your Honor. Will the defendant rise? And Maurice and I stood up. And the bailiff handed the verdict forms to the judge, and the judge read the verdicts. We, the jury, find the defendant, Maurice Jones, not guilty. And I felt like Perry goddamn Mason. You know, it just was a great feeling. I hooped and hollered. I said to the judge, I said, I want you to enter judgment on the verdict and order Mr. Jones released from the county jail instanter. And the judge at 2 o'clock in the morning hammered his gavel and said, so ordered. He left. I left. I hugged Maurice. I hugged his dad, and I went home. One of the great feelings in my life, really, really, really one of the great feelings in my life. At Sunday afternoon, this was Saturday morning at 2 o'clock. Sunday afternoon, I get a call. 2 blocks from Maurice's apartment, a woman had been found with her hands tied behind her back with a coat hanger. She had been killed, strangled to death. And my heart sank. Maurice, you son of a bitch, you couldn't wait 48 hours before you committed your 3rd murder? All of the joy, every ounce of joy of winning that case dissipated, and I was burdened with a great, great feeling of fear and sorrow that I had been responsible for allowing this to have occurred by winning the trial. I felt terrible. On Monday, when I arrived at my office the next day, I learned that the Department of Corrections had a parole hold on Maurice. And although the judge had ordered on Saturday morning that he be released instanter right away, he was still in the county jail. So all of my thoughts that I had somehow got a guilty man off, that he had committed the murder and then again the second murder, were wrong. Were wrong. He in fact was not guilty of the murder that he had been acquitted, and could not have been guilty of this new murder because even though it appeared the same, coat hanger, tied behind the back, strangled, it couldn't have been him. He was in jail. And the lesson that I take from that, and the lesson I want students that are interested in a career in law, the lesson is you have to adversarially challenge the evidence. We never know, even though we may suspect that our client is guilty. We never know. We have to challenge the evidence. And that's a joy to do. It's a burden, but it's a joy. And if a jury says not guilty, they do it for a reason. So the lesson I take from Maurice, and the lesson I want people that hear this story to take, is you can never presume guilt. People who presume guilt, we call them prosecutors, are often wrong. You have to presume innocence, and you have to fight for the presumption of innocence, because that's how justice is really served. We could have been in a death penalty hearing on Maurice, and he would have received the death penalty. But fortunately, he was spared that by a not guilty verdict that was a just and true verdict, even though I had suspicions that was wrong. I think it's a wonderful story to teach and a wonderful starting point for our conversation this afternoon.
Definitely. That seems to be a formative case for you. You talked about feeling guilty. If Maurice had in fact gone out and committed that murder, you would have felt partly responsible by virtue of doing your job, essentially. So you must believe then that to be a criminal defense attorney, you must be able to live with some amount of guilt. Theoretically, your clients will reoffend.
Austin, I was raised in a Jewish household. I live daily with guilt.
Well, I was raised Catholic, so I'm familiar with guilt, but yeah, no.
Same difference. All kidding aside, lawyers who take it upon themselves to defend a person charged with a serious crime take on a huge burden. And there are rewards with that burden, but there certainly is pain often with that burden. I also tell people I've been a Cub fan all my life. And being a Cubs baseball fan, you learn how to take a chest punch. You learn how to accept losses. The Cubs were just on a tear of 10 losses in a row a couple of weeks ago. It's just part of who I am and what I do. But you also know how to fight, and you also know how to hope, and you also know how to win. At the end of every Cub game these days, they sing a song, Go Cubs Go. You may have heard it. The song was written by a guy I went to college with, Steve Goodman. And I remember sometime in the middle of my sophomore year sitting in the sort of student union at the college, and Goodman said that he was dropping out of college. He was a pre-med major, moving to Nashville and going to become a folk singer. And I said to him, Steve, that's the dumbest thing I've ever heard anyone say. And I'm so glad he didn't take my advice, because he made the world a better place by his music.
Wow.
Go Cubs Go is the least of it. He also wrote City of New Orleans. He also, his songbook is great, and he was great and died too young. But that's not what we're here to talk about. Yes, it is a burden, but it's a burden that you have to learn to accept. And you also have to learn how to close a loss and move on to the next case, because we do lose cases. It isn't not guilty after not guilty after not guilty after not guilty. There's every Christmas I send Christmas cards to incarcerated clients. I learned over the years that many of my incarcerated clients have no one to write to, have no one that writes them. Their families have disowned many of them. And so I make it a habit every Christmas to send cards to clients that I'm represented who have found the wrong end of a verdict.
That's excellent. That's excellent, Mr. Stone. I recall hearing something in a trial lawyers college. I don't know if you're familiar with the trial lawyers college in Wyoming. Yeah,
sure.
I heard some. Yeah, that we're to attend to the human dimension of our clients, maybe most of all, especially in the case where they're required to testify, because it will be the experience of their lives, and in serious cases, that's exactly what they're fighting for. So as you point out in your story, the stakes are extraordinarily high. Even when you win, you may have some kind of lingering guilt based on what happens to the person afterward, whether, if they die some other way, or if they go back to reoffending. There are these more ethical considerations of criminal defense. Practically,
you ask a question that you shouldn't have asked, or get an answer that you weren't expecting to get, and that question or that answer resulted in a verdict of guilty, you carry that with you for the rest of your life. You
Right.
have to learn to live with it, but you carry that for the rest of your life. There is a story, I think it's apocryphal, but it's a good story. Two co-defendants charged with robbery of a gas station and the killing of the gas station attendant. And at trial, and it's a death penalty case in Georgia, the death belt, where they really know what the death penalty is and they really execute. At trial, a joint trial, a witness is called by the prosecution, and the witness says, under oath in front of the jury, Mary Beth told me that Ellen had said, and one lawyer stands up and says, objection, and sits down. The other lawyer in a joint trial stands up and says, objection, that violates my client's right of confrontation, and sits down. The judge, who in the telling of this story, I always imagined to be Ernest Gwynn in My Cousin Vinny, looks at the lawyers and says, denied, and the jury convicts and sentences these two men to death. The case goes up to the Georgia Supreme Court, and the Georgia Supreme Court affirms the sentence of death. They go through post-conviction and then habeas corpus in federal court. And they're both filing federal habeas claims. And the federal judge says, as to the first defendant, whose lawyer only said objection, under Georgia law, objection is a relevancy objection, and I find the evidence to be relevant. Defendant number one, you go to the gallows, you're going to die. But as to the second defendant, where his lawyer said that the statements of the witness violated his constitutional right of confrontation, I agree with that. Defendant number two gets a new trial. Now, I think that is outrageous, but I can't imagine the guilt that lawyer number one had to feel for not using the words that would have saved his client's life. And of course, in every trial, as we look back on the trial, whether we win or lose, there are moments where you should have said something or shouldn't have said something, and you did. And that is a huge burden. And it ought to be. You ought to be scared every night before you start trial. I've tried hundreds of cases to jury. I've tried over 130 murder cases, and I'm scared every time I walk into a courtroom. I argued a case in front of the Illinois Supreme Court, the death penalty case, some years ago, and the Supreme Court in Illinois has this gorgeous old marble-topped podium. And I argued, and when I got done with the argument and moved my hands, I saw two pools of sweat on the marble. And I knew that that was because I was there and I was fighting.
You know,
if that sweat ain't there, you're not doing your job.
I had a similar experience once in an evidence class, but something tells me that the stakes in your case were a lot higher than mine. But yeah, I understand the sense of fear. I noticed that some of the best trial lawyers talk the most about being afraid. Jerry Spence just talks endlessly about always being afraid and having to use fear as a motivator. Thomas Mesereau has said effectively the same thing about Michael Jackson. How do you use fear as a motivator? I think that when people experience fear, it's such a repellent, almost awful force. And the first thing you want to try to do is do something to make yourself more comfortable or something to avoid it. How do you run into it and use it as a positive force as a criminal defense lawyer?
Well, as I said earlier, my number one solution for that problem is to have Bernice Stone as your mother, because fear was a great motivating part of my early childhood, and always told to overcome fear. One of my mother's old sayings was that You can't ever make the butterflies go away. All you can ever do is make them fly in formation. That's my mother.
That's
You
clever.
know, yeah, I did. We could spend another hour talking about her. She was a great lady, and really helped shape a person, an adult, who still knows fear and experiences fear, but understands that it's a human emotion that has to be understood and dealt with. It's part of life. It's part of life of every animal on the planet, and we're no different. And we can learn from fear. We can embrace fear, and that's, I think, what good trial lawyers have to do.
Now, with respect more to the tactical elements of trial advocacy, what would you say are some tactics that you practice in cross-examination that might be unique or particular to you? Do you have a particular style of cross-examination? Is there a way you prefer to go about it? How do you cross-examine?
I do. The art of cross-examination is the art of controlling the witness.
Yeah.
So to gain control, I ask a single fact, declaratory statement with a question mark at the end of it. Not
Terry McCarthy.
Right. What were you doing? Or where were you going? Who, what, where questions are interesting questions, but never, ever for cross-examination. And then in trial preparation, I take a single sheet of paper. I write down at the bottom line that I want the jury to get. The car was red. I then back up as many single point declarative statements as possible, leading to the bottom line, the car was red, but I never ask the bottom line. I let the jurors ask it from the questions that I'm asking. So a single fact, declarative statement that is unambiguous. The way people get in trouble in cross-examination is by either asking a who, what, where question and letting the witness talk, or asking a question that is ambiguous and uncertain. It was a pretty expensive watch, wasn't it? Well, a pretty expensive watch for one guy may be, a Seiko that's not $995. A pretty expensive watch for another guy may be a Rolex that's $22,000. If you ask somebody, it was a pretty expensive watch, that's hardly a clear statement. If you say it was a gold watch, and you don't know whether it was gold or gold plated or just gold colored, you're not asking the right question. So you can get them to see that it was a pretty expensive watch, but you have to back up a bunch of questions. You were wearing a watch. It had a leather strap on it. The leather strap had a gold-colored clasp. The watch itself said Rolex on it. Now everybody knows that it's an expensive watch. You don't have to ask him if it was expensive. And you lead down to the last question. He was wearing a pretty expensive watch, but you never asked that question. That's the pattern of cross-examination. In my trial notebook, I will have prepared ahead of time questions for each witness, the bottom line and the single fact questions starting at the top and working down to the bottom line on every topic possible. The car was red, there were 3 people in the car, and they will all be loose leafed in my trial file. I can then arrange them in any order I want based upon the direct examination. But then I have an outline that's fluid and changeable for the trial cross, based upon my prep work ahead of time. Cross-examination is nothing that should ever be winged. It is something that must be thoughtfully prepared, and you don't cross unless it's going to advance your theory of the case.
That's the first rule, is don't.
You don't ask questions just because it's fun to cross-examination. It has to advance your theory of the case. Many years ago, I had a trial partner. His name was Isaiah Gant, Skip Gant. Skip is a federal defender in Nashville now, maybe retired, but until recently was a federal defender in Nashville. And Skip and I were trying a case, and I'm in the middle of a cross-examination. And Skip comes up to the podium and hands me a note. And this is the note he handed me. SYMAD, S-Y-M-A-D. And I said, I don't know, Judge, can I have a moment, please? And I went back and I said to Skip, SYMAD? He said, sit your monkey ass down. I'd covered what I needed. I got what I wanted. Get out before some harm is done.
Yes.
And I've never forgotten SYMAD. And maybe your listeners will always remember, sit your monkey ass down. When you've got what you need, you're done. Go on to the next set of questions or sit down. So I've learned how to sit my monkey ass down.
Yeah, I read F. Lee Bailey's book on cross-examination. He says the first rule of cross-examination, if you can apply it, is don't.
Right.
If you can get away with it. And I think that's smart. You don't risk, bringing facts to light that could hurt your client.
Now, the other thing that should be said about cross-examination is that if you read a transcript of a good cross-examination, this is how the witness's responses should be. Yes, 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 no, 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 yes, 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 yes. All the testifying is done by the lawyer. I'd love in cross to be able to walk after a cop, especially, or a snitch. After one of those guys have testified, I'd love to be able to walk up to the jury box and go, can you believe this guy? I mean, my God in heavens, look at how he lied throughout this testimony. But they don't let me do that. What they do let me do is cross-examine. And by cross-examining, I get to make the exact same thing. I'm doing almost all the talking, and the witness is either saying yes or no. That's the perfect cross-examination, with some exceptions.
Yeah, I would say that I would agree. That's the general rule. I can only think of a few exceptions in cases where if they don't mess up, you're not going to win. So hopeless cases, you're looking for, you want them to try to fight with you versus just answer yes or no, which honestly would be the easiest way for the witness anyway, because denial is what the examiner hopes for, so that impeachment can occur and then you can beat that witness theoretically. So yeah, it seems to me in close cases, especially like maybe federal cases with FBI agents who are trained to deal with cross-examiners and know the rules of cross-examination, the techniques we've talked about, I would say, yeah, fighting would be, you would want that to happen. Fighting should be encouraged. Find that to be true, that there are cases where you want the witness to fight with you, then, yeah.
There are certainly cases where if I'm going to fight with a witness, I first have to get permission from the jury to fight with that witness.
Right.
And you can get permission if the guy's giving you smart answers, or he's giving you no answers, or if he's giving you weasel words, looking like a weasel. If he's giving weasel answers, you will gain permission to do that. And frankly, jurors enjoy it. I mean, imagine being a juror. What if anything happened next? What if anything happened next? And where did you go? And what if anything? It's boring as hell. And then if you can engage them with some entertainment that also advances your client's cause, you've won them over without ever giving a closing argument. So yes, I agree with you. There are witnesses with whom you will spar, but you have to earn permission to spar with them first, and you cannot treat every witness the same. You know, a witness who is wrong on a fact may be a liar or may be mistaken. And you treat people differently if they're lying or if they're mistaken. And by the way, we, the lawyer crafting the cross, may in some instances be able to determine in the way we treat the witness whether we want the witness to be seen as someone who's just mistaken or someone who's a liar. And if we're successful at that, the jury will see that witness in different ways. Well, we can't trust that witness. They just didn't have the facts. Or we can't trust that witness. That witness was lying through his teeth. Those are different cross-examinations. The way you present the cross-examination is different. The tone of your voice, the way your body moves, how close you get to the witness, all of that is based upon how you want the jury to perceive the witness. Just wrong or a liar, for example. I mean, there's certainly shades within that spectrum too.
So let's talk about the positioning when you're cross-examining a witness then. So do you ever ask the judge's permission to get out from behind the podium during cross-examination? Or or do you just know that they're never going to let you do it, so asking would be foolish?
There are some judges who will rein you back in, but I like to use the full well of the courtroom in order to communicate things. For example, if I'm talking to a witness about my client's home and a bar where something happened, and I know that my client's home is 2 miles from where that bar was, and that's relevant to the case, I will walk over to a location in the courtroom and say, now I want to talk to you about Joe's Bar and Tap. And we'll describe it. And I'll use my hands to say, Joe's Bar and Tap is right here. Now I want to switch over to where my client lives, and I'll point way far away, and I'll move over 20 feet. And I'll say, now, this is Joe's apartment. You've been there. You know that it's on the 2nd floor, and you know that it's a brick building. What's the address there? And if my client's not going to testify, I may do this. I say to the witness, what's the address there? Jimmy, what's the address? 203 70th? 203 70. Now the jury's heard my client speak. They know that I'm relying on my client for him, but he never takes the witness stand.
That's very clever.
Now the jury has 2 places in their mind: Joe's Bar over here, and way over here, my client's home. When I'm doing a closing argument, if I'm talking about things that happened in the home, I'm talking from over there. If I'm talking about things that happened in the bar, I'm talking where the bar was located. And those 2 spots in the courtroom become, for the jurors' memories, where those events happened. And that sometimes makes a difference. My teacher on that, to give attribution to this, is a fellow by the name of Joe Guastafaro. Joe is a trained actor, PhD in theater, has directed stage and opera. He directed Chicago Opera for Artis Kranick. He's been in movies, major film productions. You've seen him in movies. He's an accomplished actor, and some point in his life, he decided that he wanted to train lawyers. Train lawyers how to tell stories, how to present cases, how to be persuasive. Because who better in this world than an accomplished actor to tell us how to tell stories and be persuasive. When Joe is on the screen, you believe not that he's Joe Guastafaro, but that he's that character, saying those words, not written by a playwright, but coming from his mouth and his heart. So I met Joe in the early 1980s. We became very good friends. He was best man at my wedding. And Joe taught me about this choreography of a trial and making the mark on the stage, the well of the courtroom, to be a certain place in the memories of the witnesses and in the hearing of the jurors. I think it's very effective. And I urge people to think about how to use the entire space of the courtroom to persuade.
I've heard a strategy where if an expert witness is repeatedly looking at the jury to answer questions, which I just find that obnoxious personally. I don't know whether that is considered persuasive or good or bad. I just personally find it obnoxious. But if an expert witness is doing that, one theory, and tell me what you think of this, is that you should, if let's say that we're facing straight on and the jury is this way and I'm talking to the jury, you should get up and walk way over here. And so when the expert witness has to look all the way back, he looks absolutely ridiculous every time, having to go from you over here to the jury. Is that right? Do you think that's clever, or what do you think about that?
I think that is clever. I don't.
Because the alternative is kind of like, who taught you to do that? Why are you looking at the jury? And I think that's too aggressive. No. Right? That's not the way to go. So
that is not
you have to use a subtler technique. So what do you think of that then?
Well, I think I try to, especially with an expert, not a fact witness, not a cop, not a snitch, but an expert. I try to engage them in a conversation. And when you're engaging someone in a conversation, it's very rare that a person will have a conversation with you looking like that. Mm. They tend to just talk to you. And I use conversation techniques, mirroring and looping language. When I say looping language, if the witness says a hemoglobin of 2.8 is, I would start my next question by saying, let's talk about a hemoglobin of 2.8. Tell me, and just try to engage them in a conversation. I think unless the witness is unusual, they will look at you, and I will lean into them. You're too young to know this, but there was a guy on television in the 60s and 70s named Phil Donahue. And Phil Donahue had a talk show where he would interview interesting people on his show. You could turn off the volume and still be engaged by how Donahue would lean into a person he was interviewing and embrace what he was saying, all without words, because the body communicates so much. There are studies that jurors will remember your being, how you present, what they take from you, far more than they'll remember any words that you speak. And that's heartbreaking for me, because I think I'm a wordsmith. I love picking the right words. I don't know that it's as effective as I'd like.
It's a populist art. It's a populist art. I mean, and it's so the highbrow wordsmithing and the soaring rhetoric of like Clarence Darrow, it seems past now. And I was talking to a Texas lawyer, a very accomplished man by the name of Dan Cogdell, who was saying that we were talking about the difference between Richard Racehorse Haynes being able to cross-examine a witness for 8 hours, whether a judge today would even let him do it, and B, whether you would even want to with the jury's attention span nowadays, especially with technology and everything. And the answer is no. If you can keep it short, short is good.
Right. Hit and get is what I say.
Yeah.
Hit and get.
tell me some more. So we've gone over looping, we've gone over one fact per question, we've gone over, you know, all this stuff. But I want to ask you, Jed Stone, you got to give me some secrets here. Tell me some more techniques, some interesting things with what you can do with a witness who tells a particular kind of lie, or, you know, some more advanced stuff. What do you think? Yeah.
You've got to know your client. You've got to spend time with your client. You know that what we lawyers do is represent. Represent is to represent, and you can't represent something you don't know. The number of criminal defense lawyers who think that their clients are merely props in the courtroom and can't figure out why they get all these guilty verdicts, it's because they never got to know and care about their client. I once represented a guy by the name of Celerino Galicia. Celerino was arrested on a Friday evening for stabbing his girlfriend 88 times in the stairwell of an apartment building. Just think about that, 88 times.
That wasn't a self-defense case.
That was not a self-defense case. So I got a call from a family member. I went to see Celerino on Saturday morning, the night after he was arrested. I spent an hour or so with him, said to him at the end of that conversation, is there anything you need that I can get for you? And he said, well, I'd really like a Spanish-speaking priest. So when I got back to the office, I called the local parish. I found a Spanish-speaking priest, and on Sunday, the priest came over. I want to drop a footnote in this story. I also once represented a guy by the name of Kayode Olujare, who was a Nigerian. And he had flown into O'Hare Airport, gotten through customs, gotten through immigration, and in the lobby of the international terminal collapsed. And paramedics were called, and when they took him to the hospital, they found that balloons of heroin had broken open and he had overdosed. So I went to see him in the hospital. He's handcuffed to the side rails of the hospital, and we're talking. And he says to me, I said to him, Kayode Olujare is a beautiful name. Tell me, what does Kayode mean? And his eyes welled up with tears, and he said, it means he who brings joy to his family. And we spent a moment on that. And then he said to me, so tell me, what does Jed mean? And I said, oh, Jed doesn't mean anything. It's just the name my mother gave me. And he said, that's too bad. I was hoping it meant he who brings freedom to Kayode. And we laughed. So
really said that. That's great.
He really said that. So Celerino, it's November, a little before Thanksgiving. He's in jail. I go see him. We go to the bond hearing. Bond is set at $20 billion or something. He stays in jail. This too is a death penalty case, exceptionally brutal and heinous, indicative of wanton cruelty, 88 stab wounds. And I cannot figure the case out. I mean, there's witnesses in the stairwell who saw this, heard her screams, came out, saw him stabbing her, saw the 85th, 86th, 87th, 88th stab. The police were called. He was there. The bloody weapon was there. His clothes were covered with her blood. There was almost nothing there. And in December, we enter a plea of not guilty, and we get discovery, and it's as bad as I expect. And in January, I'm still going to the jail to talk to Celerino, but we're not getting anywhere in terms of, and the judge is saying to me, when are you going to answer discovery? When are you going to answer ready for trial? We're not there yet, Judge. Give me some time. This is an important case. March, April, the judge is saying, get on with it. And we're not there yet, Judge, please. June, that's 8 months after the crime, I'm sitting in the jail talking to Celerino, who I've visited every week for those 8 months. And Celerino looks up in our conversation and says, well, you know, she was a witch. I said, no, I didn't know she was a witch. Why didn't she tell me? Why didn't she tell me? He said, well, I didn't think you'd believe me. So what makes a criminal trial lawyer a good trial lawyer? Having that connection with his client so that the secrets of their lives come out, because I didn't think you'd believe me. He now knew that I would believe him. He now, after all those months, knew that.
Did you get him acquitted?
No, but I got the death penalty off the table.
Hey,
and I got, I think, a 30-some year sentence at 50% at the time for 88 stab wounds.
That's a victory.
And I put on a professor from University of California, Irvine, I think. His name is Ari Kiev, and he wrote a book called Curanderismo, which is about Mexican folk witchcraftry. I'd never heard of brujas.
Yeah.
I'd never heard of them before.
My grandma used to tell me stories about brujas. Yes, no, I was afraid of them when I was a child.
Was so was Celerino. Celerino's mother wrote him letters that I didn't even know existed, that said, don't eat the food that she feeds you.
Wow.
Because she's poisoning you.
Yeah.
And it was absolutely clear that he was scared to death, that his whole family was scared of her. And it was also absolutely clear that in Mundelein, Illinois, you couldn't go into the yellow pages and find a curandero. There just were no curanderos available in the yellow pages. So he killed her. And he didn't think I would believe him. And the key to that case, the key to avoiding death, the key to getting a sentence you could live with was listening, accepting, earning trust, and then learning truth. And that really is, that experience changed me as a lawyer. During the course of the pretrial, the judge was telling me, you can't use witchcraft as a defense. There's no such thing as witchcraft. Don't come into my courtroom with this witchcraft thing. And one day after a court hearing, I said to the judge, Judge Barbara Gillerin Johnson, I said to Judge Johnson, Judge, Celerino is asking if he can have some of your fingernail clippings and a couple of hair strands. Oh no. I said, Judge, what do you have to be afraid of? There's no such thing as witchcraft. I've been hearing that from you for months. Wow. He's not getting my fingernails. He's not getting my hair strands. So I don't know that had any real effect on the case.
Jed Stone, aptly named. Wow, that was brave of you, Jed.
I've never been known as timid.
You didn't strike me as timid. So I guess that means I'm a good assessor of character then. Okay, Jed. So tell me some more about trial advocacy. So opening and closing arguments, anything special that you do? I mean, what's your style? What are some techniques you can share?
As I develop a theory of the case, pre-trial, months before pre-trial, I carry.
You start with closing, right?
I do.
Okay.
I carry I don't know where it is. It's in my briefcase. I carry a little notebook with me. And I jot down thoughts about the case, words and phrases that I want to use. I'm always asking myself, what's the best word? You know,
me too.
They fought. No, they didn't fight. They struggled. No, they didn't. It was a scrum. I try to find the word that I want then when I get those words in my trial notebook, I try to incorporate those words in jury selection so that they've heard them. I try to put those words in my opening statement as I describe what the evidence is going to be, but I never use what the evidence is going to be. I just tell the story. In the event that I get interrupted, I say the evidence will show, and then I go back to telling the story. When I'm cross-examining the state's witnesses, I'll throw in those same words. so that the jury is beginning to perceive that there's something about scrum that's going to make a difference in this case. And of course, in my direct examinations, I use some of those words again. And in my closing argument, I use those words again, so that the tapestry becomes a whole. And it's a whole created by words after I'm saying, what's the best word? Then there's a whole thing about how do you present an opening statement or a closing argument? I don't write it out, but I certainly write out phrases and words. And then I practice those phrases. And I think this is overlooked by most lawyers. My father told a story about going to England in the 1950s, and he was on a tour of the House of Parliament. And there was the robing room and the wig room and this room and that room. And then there was this little room, little larger than a closet, that had a waste can in the middle, overflowing with crumpled paper, and 3 sides of mirrors. And my father said to the tour guide, "What is that room?" And the tour guide said, "Oh, that's the room where Sir Winston practices his extemporaneous speeches." Isn't that a wonderful idea? A place to practice extemporaneous speaking.
That is pretty wonderful. Yeah.
Yeah. So that stuck with me. And of course, you know, if it was good enough for Winston Churchill, it's certainly good enough for Jed to try. I will take, and this is something that Guastafaro taught me. If you take an appellate court opinion, the sentence is, in early August 2014, the defendant, Marcellus Witherspoon, was charged in a separate case with domestic battery and criminal trespass to residence. Suppose that's an important phrase that you want to use in your, the way Guastafaro taught me to do it is you take one word at a time and you say in what? In early what? August. In early August when? 2014. What? The defendant, what? Marcellus Witherspoon, what? Was charged in a what? Separate. So you get each word having an independent, important meaning in the sentence. And then you play with what words you want to emphasize and what words you want to de-emphasize. What's the word in that sentence? This isn't a particularly good sentence, but let's say that the words domestic battery in that sentence were the words that I absolutely needed the jurors to remember. In early August 2014, the defendant, Marcellus Witherspoon, was charged in a separate case with domestic battery and criminal trespass to residence. That's the way I would practice that extemporaneous line in a mirror. I'd listen to how the words sounded. I'd listen to which words I wanted to emphasize and de-emphasize. And it would be a conscious decision on my part, looking not only for the precise word that I was looking for, but also how I wanted to emphasize or de-emphasize those words in a sentence. That's a lesson that you don't learn in law school. Even in a good trial practice class, you don't learn that stuff. And it's how to persuade. How to use your hands and invite an answer, or how to use your hands and repel an answer. The jury understands and gets that. They'll see it. And those are persuasive techniques. Closing argument, I love closing arguments. I love to be able to tell my client's story, to represent his life or her life, and to advance a claim of innocence. We just tried, a law student just walked in and sat down in the corner here, he's listening. He and I just tried together a murder case with a defense of NGRI, not guilty by reason of insanity.
Did you prevail?
We did, and I'll tell you.
Congratulations.
Thank you. I will tell you my favorite moment in the trial. the judge told me that because we bore the burden of proof, we got to go last, which is a huge advantage. Usually the state goes, I go, the state goes. In this case, the state goes, I go, the state goes, and I get to go last because I have the burden of proof. And the judge granted that to me. So the state goes, I go, the state goes, and I'm sitting at counsel table, and it's my turn to go last, which is a wonderful thing. By the way, footnote, I am told that in the state of Minnesota, the defense always goes last, which has caused me to recommend to many, many clients, drag the body to Minnesota.
Now, can you take the deposition of criminal witnesses in Minnesota?
No. Oh, in Minnesota, I don't know the answer to that. But at any rate, getting back to the NGRI,
Yes.
Here I am at the table. It's my turn to speak. And as I slowly get up from the table, before I move away, I look at the judge and I said, you know, my mother was an English teacher and my older sister was an English teacher. And they taught me that some of the most difficult questions in life are not settled only in courtrooms. They're sometimes discussed in great, deep detail in literature. And that caused me last night to think about John Steinbeck and Of Mice and Men. You know, the I done a bad thing, George. He certainly understood that he did a bad thing. He certainly understood that. But it wasn't because he had a consciousness of guilt or because he appreciated the criminality of his conduct. It was because he felt like he had let down George. And lo and behold, in his ruling, the judge said, you know, I too was thinking about Of Mice and Men, and this is, you're right, this isn't consciousness of guilt or appreciating the criminality of conduct. And he found him not guilty by reason of insanity. And I love that moment of drama as I got up and started talking about where are you going with this? Talking about my mother and my sister who are English teachers and the reason for literature. And all of a sudden turned it into a legal argument of not guilty by reason of insanity. I don't know that anybody in the world loved it as much as I did, but I really loved that moment. And that's the kind of law students and undergraduates planning to go to law school have asked me for years, what kind of courses should I take? You know, should I take a chemistry class or should I take a biology? Of course you should take a chemistry class, but I want you to take literature classes. I want you to read good storytellers telling compelling stories, because that's how you're going to win cases.
When I was in undergrad, I emailed Roy Black and I asked him the same question, and he gave the same answer. He said, read literature for meaning, have debates about it, classes emphasizing that. So you both gave it. That's and consistent.
Yeah, and I mean, Roy Black is a great lawyer. I'm just compared to Roy Black, I'm just a journeyman.
Well, I wouldn't have had you on here if I didn't think that you were of the same caliber as my other guests, who are also very good lawyers. So, and also, Jed, by the way, before you keep going with this humility thing, I'm going to give you a big head and tell you that if I ever got in trouble in Illinois, I would be either you or Thomas Breen or Dan Webb, who I would call.
Well, the three of us are all available if you have a big enough checkbook.
Even you at the maybe I expected that from Dan Webb, maybe, but you, Mr. Stone.
You know, years ago.
This is about justice.
Years ago, there was a book written about the Nicaraco case in DuPage County, and the author of the book quoted me as saying, "What attracted me to the case, I was Rolando Cruz's second team lawyer. According to the author of the book, what attracted me to the case was the stink and the ink. The stink because what they had done, what the police had done, what the DuPage County prosecutors had done was horrible. And the ink was people are going to write about it and my name was going to be in it. There's there's truth to the stink in the ink. I thought that was a good phrase. But the other thing I would say on that very subject is, while the press can be used effectively to advance your client's cause, if it doesn't advance your client's cause, don't go near it. Everything that you do, including picking up a pen during an examination of a witness, everything you do has to be done for a reason. Every time you uncap the pen, jurors are looking. What's he doing? I saw Jerry Spence try a case in Chicago some years ago, and he didn't take a note. I didn't see him write anything down. And his cross-examinations were spellbinding. And he also blew kisses to the jurors, which I never really understood.
About Spence, I mean, what are you going to say? That guy, he's a personality, and some people can, and he's got an intellect as well, obviously, clearly, but sometimes I think he leans very heavily on his personality in his cases. Well, to great effect, certainly.
He's fortunate to have a personality that you can lean on, right?
That's exactly right.
Yeah, I mean, not all of us have that. I'm just lucky that I had Bernice for a mother.
I think that that's awesome that you have, that your foundation in the principles you believe in at your law firm now began, so early, really. And rather than just a formative experience, these were your formative years by definition, is when you were very young.
We were leaving synagogue story. There's writing on the wall in Hebrew. I'm 6 years old, 7 years old. I don't read Hebrew. I barely read English. I say to my dad, what is that? And my dad says to me, oh, that's from the prophet Micah. It says in English, it says, what does the Lord require of you? And the answer is only to do justice, to love mercy, and to walk humbly with God. And my father said it in such a way as to tell me, your function in life, Jed, is to do justice, to love mercy, and to walk humbly with God. I tell people kiddingly, I've got 2 of the 3 down pretty good. It's this walking humbly shit that I'm not very good at. But doing justice and loving mercy, I try to do justice, and I do so love mercy. I so love mercy. And I want it to be a cornerstone of my representing people. I don't want anyone to be judged by the worst 10 minutes of their life. I want them to be judged by their whole life. And very few people I've met are evil people. They've certainly done bad things, but very few of them are that. There are very few people I've represented that I haven't grown to like, even people that have done horrible things. I have a recurring dream, true story. I have a recurring dream that Adolf Hitler comes into my office and wants to hire me. And of course, I'm repelled by it. I lost family members in the Holocaust. I know survivors from the Holocaust. If there's a man in this world that I think is worthy of hate, it would be Adolf Hitler. Maybe Donald Trump, but Adolf Hitler for sure. I'm kidding about Trump. I'm only saying that because of the law student here who's a Trumpian. And in the course, in this dream of talking to Hitler, I grow to like him. And that's really scary.
Yeah, that is scary. And I've reflected on this as well. I mean, to me, it kind of almost started with Martin Scorsese, with those films that made the violence of the mob funny, and that made those kind of characters not only understandable, but actually someone you would want to hang out with, and someone who, like, if you saw them doing something suspicious, like, you probably wouldn't say anything because they're a cool guy, even if you know that they're doing things, with the mob. I think that has a lot to do with what you're talking about, looking into your client and seeing and growing to like them as a person, understanding them.
And
Yeah.
understanding their story. I don't believe that anybody is born a murderer.
Mm.
I think as you enter the world, passing through your mother's body, you come out unmarked with bad behavior. And most of that has to be either developed or learned. There was a study done some years ago by maybe in the New England Journal of Medicine. They studied the populations of death row of 13 states. And they found that 85% of the men on death rows in those 35 states had frontal lobe epilepsy caused by early childhood trauma. My God, doesn't that tell you something?
Yeah.
Doesn't that tell you something? I got a call on a Sunday night years ago from a Boyd lad. He called me and said, my wife just got arrested. I think we're in a lot of trouble and we need you. So I went to see Wanda the next day, and Wanda was a young woman, probably 20, 21 years old, with 3 children. And she had killed them. And she was a soft-spoken, sweet, gentle, pretty woman. And I could not figure out how this was possible. I had a psychiatrist that I was working with, a forensic psychiatrist. His name was Leo Goodman. And I'm talking to Dr. Goodman, and I said, I can't figure this out. He said, when are you seeing her again? I said, I'll go see her this afternoon. He said, well, what you ought to do is ask her about her earliest childhood memories. And I said, I'll do that. So I went and saw Wanda, and I said, look, I want to ask you a question. You're going to think it's really weird, but I want to ask you about your earliest childhood memories. And I'll tell you mine if that'll help you. And I told her my earliest childhood memory was being on a lawn playing catch with my older cousin, Dick, and my foot got stuck in a mole hole and twisted my ankle. It's a combination of beauty and fun and gentle, good memories, and then this traumatic thing about hurting my ankle. That's my earliest childhood memory. Wanda said my earliest childhood memory was being in the kitchen of our second floor apartment in North Chicago. And the tiles were black and white tiles, and she made signs this big, as if the tiles were really big. I don't think they were that big. I think she was just really small. And I was playing, and my toy got stuck underneath the claw-footed stove. And I was trying to get my toy out. And I heard my father come up the stairs and come into the kitchen through the back porch entry. And he saw me on the floor trying to fish my toy out. And he was coming home from work, and he was wearing those steel-tip boots that he was wearing. And he kicked me over and over again like a football. And that's her earliest childhood memory. My God, if that's your earliest childhood memory, is it so impossible to understand how it is that you killed your babies? The prosecutors and I were set to go to trial on the Monday coming up, and on Friday afternoon, I went to them, and I did something that I've never done since. I cried. I said, we cannot put this woman in prison for the rest of her life, let alone put her on death row. We cannot do that. And when I left the courtroom, the office, the state's attorney's office, I left with a 15-year second-degree plea. And I went immediately to the jail to tell Wanda that we had a plea if she would take it, and that we weren't going on trial on Monday for a triple homicide. And she said, the prosecutors was, I don't need to name his name because because this is going to be seen somewhere, and he is now a judge. But
Of course.
She said there was a prominent feature of this, a physical feature of this prosecutor, and she said to me, "Tell that bucktooth motherfucker I'll take the deal." And so we did take the deal. And years later, when she got out, she came to my office like the day after she arrived home. And I said, "What are your plans?" And she said, "I'm going to get a tubal ligation." And I said, "What a wonderful plan." And she's been out for years, and she's going through life. And Boyd is still with her. You have to listen to your client and learn their stories. And you have to accept them, not as evil people. Here, you want to know something I really want to teach young lawyers who defend criminal cases?
Yeah.
If you got a call as a lawyer from Ford Motor Company, and the president of Ford said, "Austin, we'd really like you to represent Ford in this series of product liability cases that we're having with the new implosion. We'll pay you really, really well for this, but we really need your expertise as a trial lawyer to represent us." And you take the case. Can you imagine ever saying to anybody in or out of a courtroom, "That piece of shit Ford, they don't know how to make fucking cars. They're terrible"? You'd be fired in a heartbeat. You'd be fired by Ford in a heartbeat. You'd never last. The sun wouldn't go down before you got a fire letter. If you go to courtrooms in America and stand with criminal defense lawyers, you hear them disparaging their clients all the time, and then can't figure out why they don't trust them. You hear them saying things about their law, about their own clients. We were in court just the other day, and I heard a defense lawyer say, "Well, if he tests dirty next week, Judge, you probably should lock him up." Well, if he has cancer and it comes back, it's in remission now, but it comes back, you probably should pull the plug. I don't understand how lawyers don't understand that you have to learn to like, if not love, your clients and not disparage them. So if there was something I would tell young criminal defense lawyers, be open to your client's stories. Know that to represent is to represent. You cannot represent what you don't know. You have to be accepting. Here I am doing the Phil, whatever his name, Donahue's motion. So those are my thoughts on criminal defense. We've gone way over time. Anything else you want to talk to me about? I'm not trying to end this.
Oh, no. I was going to end it on that note. I think that that's fantastic. Jed Stone, thank you for being here and being interviewed by me and putting forward your advice to the young lawyers who watch this, and also some practicing attorneys who could no doubt learn a thing or two. I'm always surprised by the number of attorneys who don't know what looping is, for instance, or things like that. But I really thank you, Jed Stone. And I have no doubt that your commitment to public service, as evidenced by the cases you've taken and the causes that you've aligned yourself with, is in large part why you decided to accept the invitation to interview, so that you could, in fact, pass on what you have to teach. And again, thank you very much, sir.
You're welcome. It's been my privilege. I have a phone that's pretty accessible. If a young lawyer needs to talk to me about something, wants to think about something, wants to work something through, call my office. It's a 24-hour answering service. There's always a human on the other end. Say, "My name is Jack Schmeckes. I'm a lawyer from Oklahoma and I need help on a case," and I'll return the call. I don't know that I'll be much help, but I'll certainly return the call and I'll listen.
Thank you. I appreciate that.